Okay, everybody, thanks so much for coming. I'm here today to talk about the Trans Plus Prison Project, which is of the chair in transgender studies here at the University of Victoria and run by Erin DeVore. I am Dr. Sarah Steele. I am a postdoctoral fellow on this project. I've been working on it for about 2 years now. And today I'm going to talk through a few things. First, I'm going to talk about some of the current laws and policies and practices around federally incarcerated gender diverse people. Second, I'm going to talk a little bit about our study and what we're doing. And third, I'm going to share the words of incarcerated gender diverse people here in British Columbia. And these are kind of organized into initial themes in our data from the visits to British Columbia institutions and interviews we did with gender diverse prisoners. But it's not a lot of analysis. It's a lot of sharing those words and some general themes that we've seen so far. So once again, I want to acknowledge that I live and work on the Lekwungen Traditional Territories and the Songhean and Esquimalt Nations. So first, I'll talk about the current current policies and procedures of the Correctional Services of Canada. So the Correctional Services of Canada, also called CSC, runs federal prisons. So if you are incarcerated for 2 years or more, you serve a federal sentence. People who are incarcerated 2 years or less serve a provincial sentence. So prisons are colonial institutions based on sex segregation. So there are only men's and women's prisons. And historically, people have been put in those prisons based on their genitalia. But in 2017, the Canadian Human Rights Act was amended to include, among other things, gender identity and expression. And the Correctional Services of Canada was forced to deal with people's gender identities and try to respect them. So there are a variety of CSC policies and practices that have been introduced that attempt to accommodate gender diverse prisoners. So what do those attempts look like? When you are first incarcerated for a federal sentence or any time during the sentence that you are serving, you can request gender considerations, which are recorded for each person as a quote unquote individual protocol. And this allows incarcerated people to have a variety of choices, if you will, or accommodations in their incarceration. They can choose their gender identity, their name, the pronouns that they want to be referred by. There's a variety of protocols in terms of who touches you, who sees you naked, who escorts you outside of the prison, right? Where they can also choose the gender of the person who performs these acts. There's some accommodations around showers and private toilet access, and again, around issues of nudity and who observes you while you are in the nude. And finally, people can request the type of facility that they would like to live in based on their gender identity. So one of the main policy that governs this is called the Commissioner's Directive 100. And this says that offenders will be placed according to their gender identity or expression in a men's or women's institution, if that is their preference, regardless of their sex or the gender/sex marker on their identification documents. There is, however, a caveat that includes the idea of overriding health and safety concerns. And in the event that there are overriding health and safety concerns, according to the institution or according to the federal government, that cannot be resolved, then the person will be placed in a site that better aligns with their current sex, as in their anatomy. So one of the things to kind of contextualize this is that there's a really big difference between men's and women's prisons here in Canada, especially when we look at high security levels on the men's side of institutions. So some of those differences for folks who haven't been to a federal prison or who don't know a lot of incarcerated folks, men's institutions tend to have high hard perimeters, okay? They have multiple fences. There's a lot of wire around the top. There's a real concern about escape, if you will. And so the boundaries are really tight. Sometimes in maximum security prisons, there are armed guards with guns at the top of towers protecting these perimeters. They have really large populations. Hundreds and hundreds of men are incarcerated together. They often live on cell blocks or ranges, which sometimes include like a social space to sit or like a kitchenette kind of thing, but sometimes they're just hallways with cells in them and no social areas at all whatsoever. Again, the guards inside of men's prisons are armed, sometimes heavily armed, depending on the security level of the institution. And generally speaking, especially at the higher levels of security, there's a culture of aggression and violence. People often have to defend themselves or participate in physical altercations or situations in order to survive inside of men's prisons. Women's prisons, on the other hand, are often multi-level institutions. So that means that minimum, medium, and maximum security are all on the same property. And the perimeter of that property is much less secure. The fences are lower, there's only one fence, there's no armed towers. In fact, there's no arms inside of the women's prisons at all. The workers are not armed. They have much smaller populations. Most of the people in women's prisons live in almost like a cottage or a house where 6 to 10 people live together in a house-like situation. They prepare their meals together. There are common areas, kitchens, couches, things like this, but everyone has their own room they can go to and close the door if they would like. There are no cameras inside of these housing in women's institutions, which is a big difference. Children may be present. There's a mother-child program where incarcerated women can have their children up to 5 or 6 years old. And there's a much more of a culture of relating to people emotionally rather than through aggression and violence. There was also a big change in the way that Canada incarcerates women in the 1990s, and they really moved towards a women-centered or trauma-informed approach because somewhere around 98% of women who are incarcerated in Canada are themselves the victims of traumatic experiences. And so CSC began to try to take that into account, and they treat men and women very differently in the federal system. So just a bit of context for everyone. So the Trans Plus Prison Project started a few years ago, and basically we work to explore the lived experiences of trans plus individuals within Canadian federal prisons. So that includes trans women, trans men, non-binary people, gender non-conforming people, two-spirit folks. You know trans plus, okay. So in order to Thanks. Yeah, I know. Okay. So in order to do this, we basically have worked on connecting with kind of like 5 groups of people. So the first is people who have direct experiences of incarceration, who are currently incarcerated in federal institutions in Canada. Second, we do focus groups with staff, both uniform staff like correctional officers and program staff, teachers, parole officers, things like that. We do interviews with administrative staff, both on site at the institutions and in Ottawa, the folks who like write the policy. And we haven't done so much of this so far, but it is our goal to also connect with formerly incarcerated gender diverse folks and with community advocates. And those are community advocates with a wide variety of opinions on whether or not or how trans folks should be housed in a federal institution. So last year, we started our research in British Columbia, and then last year, 2024, and then most recently, we have been traveling to Ontario to once again talk to incarcerated folks and staff on site about the issues that are being faced by gender diverse folks in federal prisons. So today I will talk about the results or some of the themes from what incarcerated folks had to say in British Columbia. So we took 5 field trips to collect data in BC prisons between January and August of 2024. And we also did a bit of online data collection when it wasn't possible to talk to people in person. We interviewed 27 incarcerated folks during this time period. And we did 6 focus groups with staff for a total of 23 participants. So today, again, I will focus on what gender diverse people are saying in British Columbia about their experiences of incarceration. So, what prisoners are saying about the use of their names and pronouns. Staff were inconsistent at best in using the chosen names and pronouns of gender diverse people that are listed in their individual protocols. As one person said, even though I'm living full-time female and I had my surgery, I still get misgendered. I've had a couple of staff where they'll forget, but I don't think they forgot. Another person said, yeah, I get it's a men's prison, but it's not that hard to properly identify someone. Yes, mistakes happen. I get that. But when it's a consistent person making the same mistake over and over and over, I shouldn't have to keep telling the person, can you please not use this? Can you please do this? One of the challenges around names and pronouns was that everything works better for staff and for incarcerated folks when there's a legal name change involved. But it's very difficult to have a legal name change while you're incarcerated, and that was a huge barrier for everyone involved. Trans folks also talked about searches. Gender diverse prisoners were discouraged from having female officers participate in their individual search protocol. Female staff would sometimes refuse to search gender diverse prisoners, even when their individual protocols required it. This resulted in delayed movements for a lot of folks. Someone said, for example, I get adverse treatment if I want to visit my family. I get placed in holding tanks because the female staff refuse to search me. And they don't understand how that makes me feel. I'm not a freak. I'm not a creep. Prisoners also talked about their requests for transfers to gender-affirming institution. Almost all of the trans women and female-identified gender-diverse prisoners that we talked to wanted to transfer to a women's institution. Many of them were not able to at that time, and having convictions or even accusations of violence or sexual assault against women or children were the main reasons why folks were denied transfer. Most of the non-binary and two-spirit people that we talked to were not interested in transferring to women's institutions. This was for a few different reasons. One, people were often afraid of incarcerated women. They felt they would be assaulted or raped upon entrance into a women's institution. They thought they would be very much stigmatized in the women's institution, and they were afraid of that stigma. And finally, many of them just didn't have a lot of trouble or enough trouble in their current men's institution to want to go through that process. When trans women were approved and transferred to women's institutions, the transfer itself went smoothly, but adjustment to the women's institution was a huge issue. As one person said, I came from 24 years in the men's prison system to the women's system, and it was a culture shock to me. I had to relearn how to do time again. Trans women also talked about treatment by other prisoners, particularly in men's prisons. They said things like, even though it's 2024, there's still a lot of stigma within the offenders. They automatically assume I'm gay and that I want to hook up with them, and that's not the case. Almost all the gender diverse people we talked to in men's institutions reported some sort of assault, physical, verbal, or sexual harassment during their time inside. Another one said, I get asked for blowjobs right in front of staff members, and the staff just laugh. It's like they think I deserve this treatment just because I'm transgender. It's my fault. And it's not. It's sexual harassment. In high-level security situations, things were especially difficult for trans women in men's prison. One, for example, said, I've been beaten up here. I've had to sit in segregation for most of my time because it's very unsafe for me here, because for some reason, inmates don't like transgenders here. They want to stab me. They want to kill me. I have a target on my back everywhere I go. There are so many violent issues that cause me harm here, and the staff don't care. Now I'm going to talk a little bit about what these folks said about how the staff was treating them, as opposed to how some of the other prisoners were treating them. So for some gender diverse folks, when they would find one or two good staff people at one of these institutions, it would take them really far. One person said, for example, my parole officer really helped me fill out my paperwork for my name change and the gender marker change. And then I came to the Women's Institution. And when I got here, I was very fortunate that, again, I would say an individual who kind of went out of her way to help me navigate this big part of my life. So there is definitely beneficial for gender diverse folks when they found a helpful or a couple of helpful staff members. But other prisoners also talked about how trans women were treated by staff in men's prisons, and that was a little bit different. The way staff talks to them, the things they say behind their backs, they do get treated differently by certain guards. I will admit that, and that's not right. Another person commented, I feel like they've been treating a lot of the transgender kindly, not because they want to, but because they sort of have to. And I think they should be treating all people nicely, not just one set or a group or anything like that, because they're fearful of being sued or anything like that. We heard a lot from staff and sometimes from incarcerated folks about human rights complaints. And the staff were very scared of quote unquote litigious folks who would sue the CSC on their own behalf. So that's what I have to share with you today. Thank you so much.
Hi, friends. Thank you for coming. Hello, people at home. I've made a PowerPoint against my will. It is available online, and I'm aware there are too many slides, but know that it will be there through the chair webpage if you need to refer to it. I've also included some QR codes, so heads up to get your phones out at the appropriate time. My work happens on the traditional unceded and stolen territory of the Musqueam, the Tsleil-Waututh, and the Squamish people. And I, as an incandescently white person, would like to amplify the calls of Indigenous people for a decolonization that necessarily involves the payment of reparations, the transfer of governance, and the return of land. I'm going to talk about some bad things in this talk. We're going to talk about various kinds of violence against women and children. We're going to talk about some murder. We're going to talk about cops. Mostly we're going to talk about state-sanctioned violence in the form of a new law. Please take care of yourselves. There's a couple of active listeners around at the conference. There's a puppy to help us get through. The punchline is that in era of terrible laws that are increasingly criminalizing us, the BC NDP government passed its own and banned name changes for people convicted of a broad range of crimes, people found not criminally responsible by reason of a mental disorder, and people designated long-term and dangerous offenders. They've also introduced a new mandatory criminal records check for all applicants over 12 that has a fee and requires that you go to a police station. And it implements mandatory record sharing between the Vital Statistics Agency of your health information with the RCMP. This ban, yes, I find it tremendously shameful. The name change ban was not necessary. It's based around addressing a problem that is entirely pretend. It can't possibly work because most name changes in British Columbia happen as a result of marriage, and people don't need to use the name change system. It's just for us. It causes tremendous harm to some identifiable groups of people, maybe by accident, which doesn't make it better. It conflicts with a number of international statutes, the Charter, human rights legislation, rules around the protection of youth criminal records. And the Premier has told me that it won't be repealed. So we're going to go to court, and you can help. There is a QR code. Yeah, let's clap about going to court and suing the government. Remember, as I tell you this part of the story, that it's entirely pretend. There's a man called Alan Schoenborn who was floridly psychotic at the time that he murdered his 3 children. The court found that he was suffering from a mental disorder, and he was found not criminally responsible under Section 16 of the Criminal Code that acknowledges that some people are so ill at the time they have a reduced responsibility for their crimes. He has been held for the last 15 years at the Forensic Psychiatric Institution, where he will stay for some time, and every year his conditions are reviewed by the BC Review Board. He is reporting some of the things that Sarah talked about. He's experiencing tremendous violence because his name is associated with this notorious crime. So he applied for a legal name change in British Columbia, and he got one. And he asked the review board if they could publish future decisions without disclosing his new legal name. He wanted them to be published in the name of Alan Schoenborn. The review board said no. So the problem is entirely pretend. It did not happen. He was not able to hide his new name, and the media reports are publishing both of his names together. Alan Schoenborn, to my knowledge, is not a trans person, but we're here to talk about the implications of this law that has a pretend problem on our community. For folks outside of British Columbia, our Conservative Party was called the BC United Party. Now it's called the Conservative Party. And the leader of that party at the time, Kevin Falcon, found out, he had been transmitting some continuous rhetoric for the preceding 7 years about the BC NDP government headed by David Eby. They talked about his catch and release approach to crime and that the NDP was insufficiently tough on crime. And they raised the problem of Alan Schoenborn having changed his name. And the two leaders exchanged some words in the press and in the Legislative Assembly. Kevin Falcon accused David Eby of helping Alan Schoenborn escape responsibility for his crimes by changing his name. David Eby responded that it was Kevin Falcon's party who removed the requirement that name change applicants publish their new name and their old name together in the newspaper. And the Premier said he would look at going back to that system, which I see from your faces, you're aware, outs people and is very dangerous for us. Kevin Falcon then proposed a private member's bill that would prevent people convicted of serious crimes, he said in the House, from being able to change their names. He didn't word it in a way that would actually apply to Alan Schoenborn. And for folks from outside the province, private members' bills never go anywhere in British Columbia. They're a way for a party to express a position, but they have no risk of ever becoming the law. Then there was going to be a provincial election. The BC NDP drifted hard to the right. It stepped away from harm reduction. It promised to expand the state's ability to detain people under the Mental Health Act for reasons of addiction and brain injury. He participated in a big announcement with the mayor of Vancouver, about $5 million for more cops in the downtown east side. The name change ban is part of this pattern. And what the BC NDP government did was take Kevin Falcon's idea, broaden it, make it worse, and then, despite the tradition that in British Columbia bills usually sit before the Legislative Assembly for 3 days, they introduced this on the second to last day and passed it on the last day. No discussion, no consultation. I don't know if they actually spoke to anyone, possibly the police. And it was a unanimous vote for public safety. Nobody thought it would affect us. I told you what the law does. It bans name changes for folks convicted of crimes. There's this new criminal record check. It compels young people to share their records, which are protected and sealed by the Youth Criminal Justice Act. We have a really important policy goal as a society to allow young people to not have their entire lives ruined by a mistake they make when they're young. And this record sharing problem, it also delays. They said in the House 4 months. You have to have your records submitted. If there's a record at all, you go on a pile, and it takes them 4 months to sort through whether your charges line up with the ones that they've banned. If you don't have a record, it's said to only delay your application by a week. What that means is that name changes in British Columbia now take between 8 and 12 months. They also made some changes in the Adoption Act so that Alan Schoenborn and people in his position wouldn't be able to get adopted and change their names. They have no idea that people can change their names by getting married, and that system is entirely unregulated because there's a social interest in people just subordinating their identity to their husbands and being somebody new. It wasn't needed. The problems pretend. You can't escape a criminal record. And people who've tried to update your name, you know how there's artifacts of your name everywhere, particularly in all of the police records. It's not actually possible to do what they said. There was already the ability for the Registrar of Vital Statistics to deny a name change brought for an improper purpose. Name changes brought by fraud could be canceled. They already took fingerprints from adults. They did nothing with them. That's not our fault. It won't protect the public because of this marriage issue, because most people never see the legal documents of anyone around them. The Premier said, oh, but he could move next door to you and tell you that his name is anything. And like, I don't know the legal name of any of my neighbors. And I don't think I need to. But They've also made an exemption that if you are a jailhouse informant convicted of some of the more serious crimes on the list, any of them, you can have a legal name change because you're collaborating with the police for a law enforcement initiative. So their argument for why this is necessary doesn't hold up. Here's a QR code that will download a 3-page order in council, which is the regulations to the name change ban, which shows you the crimes that are listed so that you can check out your own record at your leisure. The problem is, in the House, they said murder. They said manslaughter. In September, they released this extremely long list of crimes, and they didn't include some fairly intuitive violent crimes that fit in the category of violent with a vulnerable victim. They didn't list things like assault with a weapon and robbery and forcible confinement and uttering threats. They didn't list some of these crimes. And the ones I'm reading to you are reported when you get a criminal record check. This is what they show. But a lot of fairly horrific charges are on this list, including conversion therapy, threatening a justice system participant, distributing images without consent, all the sex offender registries, all the organized crime and gun and gang and explosive charges, drug trafficking, not on there. Trust and money laundering charges are not there, even though the constant rhetoric about us is that our name changes are fraudulent. They did list some nonviolent crimes, like trespassing at night and breaking and entering. They did list charges traditionally used to criminalize queer sex, like gross indecency, indecent acts, exposure. They did list a whole bunch of charges that apply to sex workers. And for adults, these crimes were struck down as unconstitutional in a case called Bedford. These are living on the avails, communicating for the purpose, procuring, which prevents sex workers from working together to protect themselves, and also charges that a person could unwittingly get. The cases I reviewed have a scenario when a young person escapes a very violent home environment, and usually with a friend or a partner, they ask somebody to give them a ride somewhere, and the someone who gives them a ride is charged with kidnapping. These also you get if you rescue your own child from a dangerous situation, because that's much more urgent than waiting for court. The harm is very clear. Restricting access to documents prevents people from exercising full citizenship. ID that has your name on it is necessary for shelters and healthcare and education and to pick up a parcel. And what it means is that trans people, Indigenous people trying to reclaim Indigenous names, people who need to change their name to get away from a very unpleasant traumatic association with a family name, or people who are running away from an abuser and need to start again. If they have one of these charges, which are more or less random, they'll never be able to change their name, and this means a lifetime of compulsory dead naming by the state in a way that we say is unconstitutional. It's the province exercising a criminal power, which it can't do. It violates the equality provision in the charter, the Section 7 life, liberty, and security of the person rules because of how tightly ID is related to basic services. We say it exposes trans people to cruel and unusual punishment. It requires young people to disclose their criminal records. And these are protected by the Youth Criminal Justice Act. So for adults, you get your check, the police send the records right to Victoria. They're not allowed to do that for young people, and they know it. So they hand the record to the young person and expect the young person to mail it in and thereby consent to disclosure of their otherwise protected records, which violates the Youth Criminal Justice Act, but also the UN Declaration on the Rights of the Child. UN Declaration on the Rights of Indigenous People and the government's own claims that it's going to help people reclaim their names is also violated. And human rights protection against dead naming and administrative law principles against arbitrary decisions by government and overreach are all in play. So we issued a press release when we got the regulations. There's a list of really minor parties like the Union of BC Indian Chiefs and West Coast Leaf and Canadian Bar Association who said this is bad and unconstitutional. These are the predictable interveners in a charter challenge against this case. And my conversations with government have not been productive. So we're probably going to take them to court. If this affects you, there's an email address on the screen, which is lawyer@cwhwc.com. We have a fund and lawyers to help you with name and gender changes for British Columbia documents. including a Van City Fund to help with the costs. If you have just changed your name and you had to pay some costs, and it involved a British Columbia document, send us an email, because that fund should end up in your pocket and not sit making the 50 cents in lint interest that it might make. I do want people to have proper ID. If you can't change your name because of the Name Act, give us a call. We are looking for a named applicant in this case. But you can also help us by emailing these fine elected people. Here's the email addresses for the Minister of Health, the Premier's Office, the Gender Equity Office, and the Attorney General. Write to them and say, repeal the name change ban. Meet with Adrienne. The next slide is a QR code where you can give us some money to help us with the legal challenge, or you can just contribute to the fund to make sure folks can get name and gender changes. If you're all done taking photographs of these email addresses, here's the last page where you can donate to us. But also, please don't hesitate to get in touch if you want some help navigating your own identity documents. We also have a fund to cover federal things, so if you need to replace your PR card, your citizenship, your passport, we can help you. Thank you, friends.